podcast. Today is another beautiful Wednesday. Thank you for joining us. Please invite your family, friends, colleagues at work. Invite us, and we are continuing with this uh, open questions and answers. I believe this should be the second week or third week. Second. Okay, so we are continuing with the series. So what that means is that we are going to take every question, irrespective of the topic. It's an open question. So, oh, look at. Oh my God! I just want to be sure that okay. Okay. So we continue with the series. It's an open question. So if you are just joining us, invite your family, friends, invite everybody to be part of this. It's an open questions. You are free, at least for today, to answer any questions you have. I believe that we have some questions from last week that we were not able to get to. Can you please send those questions? So let's start so that I don't waste a lot of time so that we'll be able to finish this question and answer sessions today. So keep your questions coming in. Today, like I said, is an open question. It's a continuation of last week. And because we have a lot of questions from last week that we were not able to get to, we will start from those ones today. And if you have questions, send them in. So I need the questions, please. From last week.
Who were they? Do you want me to start?
This is Dr. Olu Asekun podcast. So today is a free question and answer session. If you have questions, send them in. We have only 1 hour, so we want to cover as many questions as possible. If you can just read it out.
Um,
I'm pulling up the list. Oh, here it is.
Are you going to send it or read it?
I can read the first one. Okay. I am on R1 status, but I would like to travel to my home country for a few days to be with my family. I do not have R1 stamped on my passport yet because I changed from within the US. Is it safe to go out to neighboring countries for stamping?
Okay, I will answer the question, but can you please send the
Yeah.
question? Because sometimes while I'm answering, I want to read the question again to be sure that I answer the question correctly. But from what I heard you read, the question is somebody who is on R1 who did a change of status probably came in with a visiting visa and then changed status to R1. So he wants to know if it is safe for him to travel to a neighboring country to stamp the R1 status. Now, this is how my answer is going to be. Number one, when this person apply for a visiting visa in his or her country, what profession did he list in his application? One major problem that people who change status to religious status in the US, one major problem they face is that majority, when they apply for visiting visa in their home country, they represent themselves to be professionals, maybe an engineer, maybe a banker, maybe a lecturer, maybe a teacher. Maybe they represent themselves as professionals so that they will be able to obtain the visa. However, when they get to the US, they change their status and now suddenly become a religious minister. The problem with that is that when you apply for visa, you are applying with the Department of State. The Department of State have record of all your previous visa applications. So if your visa applications did not indicate that you are a minister, but you only changed to a religious status after you got to the US, that may give you some problems if you go to a neighboring country to apply for R1 visa. This is the solution. After coming to the US, if you attend a religious education, if you obtain a form of certification, even ordination from an American institution or American religious organization, then if you go to a neighboring country, when you are talking about neighboring country, you are probably only talking about Canada and Mexico. Those are the only two countries that surround the United States. So if you go to, except if you are talking about the Caribbean, if you go to a neighboring country with a certificate or documentation obtained from the United States, yes, and you have one, you have evidence of your employment as a uh, religious minister. Maybe you have your payslip, you have your W-2, you have your tax return, and then you have evidence of religious certification or education in the United States. Yes, you may find it easy to get R1 visa from a neighboring state. But if you don't have those things, I've seen people who apply for religious R1 visa from Canada, and the US Embassy in Canada told them to go back to their home country to go and apply because they are not able to verify the documentations they provided. These are people who provided evidence of ordination or religious education from their home country. But remember, they didn't disclose this when they were applying for visa. So there is tendency that the embassy can send such a person to their home country to go and apply for R1 visa. And of course, if you are from a country like Nigeria, you need special grace to get that visa. Now, the next question: is it safe to go out to neighboring countries for stamping?
That was the same question.
That was the same question. I believe I've answered that. The question: my I-485 application was denied. Is there any way to appeal the denial? Well, this question is not detailed enough. I don't know why it was denied. First and foremost, I-485 is a discretionary application. You cannot appeal. However, you can file a motion to reopen and address the reason for denial. If you believe that the denial was in error, you can file a motion to reopen. You can address the reason for denial, and it can be reopened and approved. We have done that several times. But to file an appeal, no, you cannot. It's a discretionary application. The next question: I'm a US citizen and my brother has a visa to the US. Can I file for Form I-130 for him here in the US or in Nigeria and still be able to be traveling in and out? Yes, filing I-130 petition for a sibling does not prevent them from coming in and out of the US. However, I must say this. Remember, visiting visa is 100% discretionary. Even if you didn't file I-130 for your brother, there is no guarantee that nobody can guarantee you that the visiting visa will be renewed. They may renew it, they may choose not to renew it. So filing I-130 for him does not have any impact on the decision of consular officer to either renew or not. I've seen this over and over and over. It doesn't affect it. they can still continue to give him visa. What is important is that he should not overstay. And when we talk about overstay for this purpose, let me explain certain things. Some people believe that for as long as they gave you 6 months at the port of entry and you spend 5.5 months, you have not overstayed. Legally, that may be true. But when we are talking about discretionary decisions, remember, the embassy have records of all the information you provided before you obtain the visa. If you tell them that you are coming to the US for a 2 week visit, maybe to attend a vacation, a graduation or something, and you get here, you stay 5.5 months. Although you have not overstayed, but it may have impact in the decision to renew or deny the renewal of your application. So those are discretionary issues. So I will advise you, if you tell them you are coming here for 2 weeks, if you are going to stay beyond 2 weeks, let it not be more than 4 weeks. Subsequent travel, yes, that may change, but that very first travel when you obtain the visa, if you tell them you are coming here for 2 weeks, to be honest with you, it gives you credibility to stay here only for 2 weeks. That will give you credibility. But the moment you exceed it, your renewal may subject you to interview and questioning and all of that. And just like any discretionary application, it may be denied, it may be approved. The next question. I think the next question is I got married to someone in the US and she passed on. After 2 years, can I marry my ex in Nigeria by filing for a fiancé visa? This question is not complete. I'm assuming, and I don't like to assume when I'm giving an answer, because what I say here is by the grace of God authoritative, and I don't want to mislead people. So this is not very clear. I don't know if this person is a US citizen, because that aspect is not clear. All he just said is, I got married to someone in the US and she passed on. After 2 years, can I marry my ex in Nigeria by filing for a fiancé visa? Well, I'm assuming that this person is a US citizen, even though the information is not clear. But if this person is a US citizen, yes, you can remarry your ex. But to be honest with you, remarrying her as a fiancé is not a good idea. It gives you more credibility and more let me say, what's the right word? I mean, your chances increase if you go back and marry her and then petition for her and bring her here, but not as a fiancé, because the fiancé thing will look awkward. I mean, this is somebody you are married to before, so how can it turn out to be your fiancé? The fact that it is not everybody that one is not married to that is a fiancé. I mean, you have been married before legally, so if you divorce, the only thing is for you to remarry again. Presenting her as a fiancé will raise a lot of questions. And let me tell you, fiancé is a two-edged petition. It can be classified as an immigrant petition. It can also be classified as a non-immigrant petition. So on the basis of being a non-immigrant petition, it could be denied on discretionary basis. So we don't want to do that. It is better you go back, get married, come back here, file a petition for her, and then bring her here. That is what I will recommend. It doesn't mean that filing for fiancé is certain that it's going to be denied. That's not what I'm saying, but I'm just telling you, a much better approach. If I'm going to advise you, a much better approach would be to just go ahead, marry her, and file a petition for her. The next question. I'm from Jamaica. My wife is a US citizen. She filed the I-130 August 2023. It's saying it's 1 week to decision. How long is the waiting to get a visa appointment? I thought we answered this last week. This was the question we answered last week. Yeah, I think so. But let me just repeat it since we are already here. First and foremost, I-130 petition is just one out of 4-stage process. So even if it is approved, you still have a long way to go. This is not so. This 1 week thing is none of it. After the I-130 is approved, you are still going to wait maybe about 30 days for USCIS to forward the file to National Visa Center. National Visa Center will process it. That is where you will submit immigrant visa application, pay the immigrant visa fee, affidavit of support fee, submit immigrant visa application, police report, and all of that. Once they finish, they contact the US Embassy in Jamaica and wait for the embassy to give them list of available dates for interview. Only after that, they will schedule you for interview. That is when you will go for medical examination. It is only after that you go for your interview, and if everything goes well and the visa is issued, you come back here and pay the green card processing fee. So it's still a long process. So I will tell you that don't make any travel plan right now. You still have a long way to go.
I have a really long one that I can't send. It's too long. Can I just get it?
Is it the next one now?
No.
I can't send it because it's way too long.
Yeah, I know, but is it the next one that I need to answer?
Well, we have just a compilation of all
Yeah.
that.
Okay, let me just let me read it.
It's way too long to send.
Okay, I'm not going to mention the name.
Yeah.
Hello, my name is Blank. I came across your immigration videos on YouTube and it all sounds interesting to me. I have a question about my own immigration status processing right here in the United States. I came into the state in 2022 with K1 Fiance visa and I was given 90 days to get married to my petitioner at the point of entry. But unfortunately, I and my petitioner didn't get married due to some circumstances. We separated, everyone moved on with life. I literally moved from Atlanta to California, so presently I'm in California. I tried all my possible alternatives to overturning the visa to student visa, but I couldn't. I was told that I have a limited time on my visa. Don't forget, it's just a 90-day fiancé visa. It was get married or fly back to your country, Nigeria. I contacted so many immigration lawyers in Atlanta and California, but the only option I had was to seek asylum, and I do. I have gotten my work authorization and social security card plus California driver's license. I met a lady here in California that we have been dating for almost a year and a half. We are both interested in moving forward, but I am a little confused about my status. I want to know if getting to USA citizen married can help me. Or maybe you wanted to say if getting married to a US citizen can help me secure a resident status in the state. I'll be looking forward to hearing back from you, sir. Thanks in advance. XYZ. Well,
That was long.
Yes.
it was a long question, but I like the fact that it's detailed because there are so many questions in one. First and foremost, I'm going to tell you that you have taken some wrong steps. That is my starting point. You have taken some wrong step by applying for asylum in the United States. Now, I don't know the fact of your asylum. I don't know the basis of the application, but I'm going to give you 3 pieces of advice. Number one, I want to, since you have seen our videos, I want you to go back and watch all our videos on Asylum. If I recollect correctly, I believe that we have about 4 or 5 different podcasts on Asylum. So I will advise you to go and watch that. Secondly, I will advise you to go also and watch our videos on Fiance visa. I believe that we have a podcast on Fiance visa. Thirdly, and this is where I'm going, first and foremost, for somebody who entered the United States on a fiancé visa, you cannot get green card in the US through any other marriage. That is the law. Even if you marry President Biden's daughter, you cannot get green card here in the United States. This is not my making up. That is the law. That's the way the Congress wrote the law. So the fact that you didn't marry the person within the 90 days, no matter how legitimate a new marriage is, no matter who the petitioner is, you cannot get green card in the United States. Now, here is the problem in your particular situation. The fact that you apply for asylum, that means that, I mean, based on the fact, if I get it correctly, I believe that person is from Nigeria. He mentioned Nigeria in that. Based, if you apply for asylum, like I said, I don't know the basis, so I'm not judging your application. I'm not giving you any advice on the application, whether it is approvable or not. That is not the point I'm making here, because I can't comment on an application that I have not seen. The point I'm making is that the mere fact that you apply for asylum, you are telling the US government that you are afraid of returning to Nigeria. That is what you are saying by applying for asylum. And here you are, you came in with a fiancé visa, which also says you cannot adjust your status in the US. So here you are on one hand saying, I cannot go back to Nigeria. Here is the law on the other hand saying you cannot get green card here because of the fiancé visa you came with. So even if the US citizen you just married now wanted to help you, that help will require you to go back to Nigeria. But your asylum application has already indicated that you are not able to go to, so you are going to be in limbo. I pray that the asylum will be approved. I pray that whatever the basis of the asylum, it will be approvable. But right now, that is the limbo that you have created for yourself. Assuming that you didn't apply for the asylum, all you needed to do was for your new.
Okay, you're back there. Maybe you want to.
I lost my line of thought.
Yeah. It was just like for about
The
5 seconds.
consulate, if you apply for I-601.
Yeah, what I was explaining is that this person, what you should have done before applying for the asylum, you should have married the US citizen, the new US citizen that you fell in love with. She should have filed I-130 petition for you. That petition should have been processed as a consular processing. Once that petition is approved, you apply for what we call I-601A waiver. That is waiver of unlawful presence. Upon the approval of the waiver, you process the immigrant visa through the US embassy, and then you go back home to Nigeria and then go to the US embassy and apply for green card. Remember, this is an immigrant visa. It is not a discretionary thing. So for as long as you and your wife are in good position and she's supporting the petition and the waiver has already been approved, you will get your green card. But the problem now is that the fact that you have now filed for asylum, indicating that you are not able to go back to Nigeria because you fear for your life, then I don't see how this problem can be fixed. So the only thing I will advise you do whatever you can to ensure that your asylum is approved. Do whatever you can. I don't know the basis of your application, but I will advise you to go and get documentary evidence to back up your asylum claim, because that would be your only option. If that asylum is not granted, your marriage to the US citizen cannot help you, because you came in here with a fiancé visa. And I've said it over and over and over again. If you enter the United States on a fiancé visa, you cannot change your status. You cannot adjust your status. It doesn't matter who your spouse is, even if it is the president's daughter or son. You cannot adjust your status. That is the law.
Except if they file. Oh wow.
Not even in this situation. VAWA cannot work in this situation, because number one, they never even got married at all.
She brought him here on a
That is if they live together.
Yes, yes.
Looking at the fact, they didn't even survive the 90 days. They didn't even, based on that fact, VAWA cannot work. That would just even complicate it more. It cannot work. Okay, the next question, I believe the next question is, I got married to someone in the US and okay, I think I've just answered that. The one from Jamaica, I just answered that. The next one, can I come into the US with my B1, B2 visa and status if my case is within? I don't understand.
So your EB2 NIW was approved and it's currently in the National Visa Center stage. She's asking.
Is visa current? What?
Waiting, and she's asking if she can come in as a visitor while that's.
Well, like I said, the question is not complete, but assuming that visa is current, yes. If you come into the US, you can apply for adjustment of status if visa is current. So, because the question didn't tell us when the EB2 was filed, what is the priority date. So we don't know if visa is current or not. If visa is not current, you may not be able, you may be creating a problem for yourself, because employment based requires that somebody is maintaining legal status at all times before the application for green card. It is different from family based petition. For family based, somebody who is out of status may be excused, but for employment based, they are not excused, and there is no waiver for it. So if visa is not current, it is not advisable for you to do that, except if you are coming in another non-immigrant status that will keep you in legal status until whenever visa is current. For example, if you are on student visa and you are going to school, you are complying with all the terms, yes, you can be doing that until visa becomes current. But except you have a way of maintaining legal status until visa becomes current, it is not advisable for you to come to the US with a visiting visa. The next question, for someone in this category, non-minister, that already has an EAD, on what basis can the EAD be renewed if this category is not renewed? Well, you can continue to renew your employment authorization based on C9 category, that is pending application for adjustment of status. You can, it doesn't matter whether visa is current or not, for as long as your application has already been accepted. It doesn't matter whether the Congress extended the non-immigrant category. Right now, it has been extended till December, so it's still okay right now. But even if it is not extended, the fact that you have submitted your application and it has been accepted, you have submitted application for employment authorization and you have been granted, the problem has been transferred to the government. Whenever they are ready, you can continue to apply for employment authorization and they will renew it. So you just apply under category C9, meaning that you have a pending application for adjustment of status. The next question. I came in a few months ago for an aviation course in flight dispatching with an M1 visa. What are the ways to change my status? Well, this is an open question. It's not the kind of question I can answer here because it will take the entire 1 hour. I mean, there are different options. I mean, M1 is equivalent of F1. So you F1 is for academic education, M1 is for non-academic education. And of course, you can change your status from M1. So if you are eligible for other non-immigrants, you can change to other non-immigrant status. If you are eligible for immigrant status, you can change to immigrant status. If you are eligible for family base, you can change for family base. I mean, there are different things, but this is an open-ended question. It's not a question I can go into. And you can also take your time to watch some of our previous podcasts. We have podcasts on EB1, we have podcasts on EB2, we have podcasts on EB3, we have podcasts on EB4, we have podcasts on EB5, we have podcasts on Asylum, we have podcasts on family base. So, like I said, just take your time, and this is an open-ended question. We will not do something else if we go into that right now. So, the next question. I have a master's degree and I work as a network engineer with a private firm. I would like to know if there are any programs that can enable my move to the US. Again, this is also similar to open-ended question. So please take your time, go and watch some of our previous podcasts. Like I said, we have discussed virtually all employment-based ways of getting legalized in the US. We have discussed almost all family-based ways of getting legalized in the US. We have discussed special ways of getting legalized. We have discussed asylum. We have discussed virtually everything. So take your time, watch our podcast, and then you'll be able to see and determine what you think can work for you. Now, if you watch any of the podcast and you narrow it down, then maybe if you come back, we'll be able to address it. But right now, your question is open-ended, and I will not be able to take it at this time because we have less than 30 minutes and we still have a lot of questions to go. The next question. My fiance filed for fiancé visa for me last year, and now we want to try the visit visa because of the delay in fiancé visa process. Is it possible to apply? Well, yes, it is possible to apply. You can apply for anything. The issue here is that this is a kind of visa that is 100% discretionary. So the embassy may give you, but they may not. To be honest with you, I always tell people it is better to marry your spouse than to go through fiancé visa. Because if fiancé visa is approved, yes, it may be faster. But the difference between fiancé visa processing and immigrant visa processing, the difference is in the National Visa Center processing. And let me tell you, if they deny the fiancé visa, you extend the processing time by over a year. So why not just go for the one that is almost certain?
We just got information that Nigeria, for example, has stopped scheduling appointments for fiancés at this time until further notice.
Did they give any reason for that?
No, for now, I mean, yes, they're just busy, but for now, they're not doing that.
Well, this is a good information. I was just being told now that the US Embassy in Nigeria have stopped processing fiancé visa until further notice. I didn't even know that until now.
If you go online to try to schedule the appointment for fiancé, after the fiancé has been approved, they tell you that you cannot proceed.
You see? So I didn't even know that when I was telling them that the best option is for you to go and marry your spouse. I've just been told now that the US Embassy in Nigeria, they have actually suspended processing of fiancé visa for people from Nigeria. So if you have a fiancé, get married and let your spouse file a petition for you. That has always been my position all along. It is much better because there is no discretionary issue there. That one is just to show that you are legitimately married. That is it.
And the waiting time for spouses of U.S. citizens to be scheduled for the interview is not that long.
Yeah.
They will have the certainty that they will be scheduled. Right?
So that is it. That is the issue. If you apply for fiancé visa, just forget it for now, especially if you are from Nigeria. Tell your spouse to come to Nigeria, get married, let her come back here, and she will file a petition for you. That is the best way, especially now that fiancé visa has even been stopped in Nigeria. The processing has stopped, so you may be waiting for a long time. Oh, we have some fiancé visa applications that have already been approved, so they were not scheduled to. Oh, unfortunately, even when fiancé visa is approved, it is only valid for 120 days.
But they already mentioned to the U.S. citizen that they will extend it because they are the ones that in the first place are not processing it until further notice. So,
yeah, further notice means it doesn't mean anything. How can you plan? How can you plan based on until further notice? That is indefinite. There is no definitive time. Further notice could be 2 years. It could be, especially depending on what happened during this election. So that further notice may never come back to life. So it's better to just go ahead, marry yourself, and file the petition.
because the whole purpose of the fiance was to bring the person before.
Yeah, it doesn't work just like that. The next question. I'm in the UK on a study visa status, and I'm looking forward to relocating to the USA. If I enter the USA on a B1, B2 visa category, can I change my status to study or H1B visa?
Oh, okay. There was a continuation to the one that you did. Is it possible? Well, but I think you've already answered it. The person wanted to know if they can come on a visiting visa.
I've already answered that.
Yeah, but there was a continuation after the question that you just read.
I've already addressed even what was stated in the continuation.
Okay.
Okay, let me just go back to this question so that I don't confuse the listeners. I'm in the UK on a study visa status, and I'm looking forward to relocating to the USA. If I enter the USA on a B1, B2 visa category, can I change my status to study or H1B visa? The simple answer to the question is yes, but it's not that easy. It may be complicated, but the simple answer is yes. But let me tell you why it is not easy. Number one, H1B is a seasonal kind of petition, and it requires you to have an employer that will sponsor you. So, and it is only processed in a particular time of the year. So if you miss that period, that is it. So if you are going to change to H1B, it will be advisable for you to already have the petitioner file the petition, get the petition approved, and let them send the approved petition to the US Embassy in the UK. For as long as you are legal in the UK, they will process it for you. But the danger of coming to the US to come and apply for H1B, number one, as I stated, H1B is a seasonal application, and it is processed ahead of time, yearly ahead. So right now, we just started fiscal year 2025 on October 1st this month. So fiscal year 2025 is going to end on September 30th, 2025. So H1B for 2025 has already been used up earlier in this year. So the next H1B is going to be processed early next year, and that is going to be for fiscal year 2026. So if you come in with a B1, B2 visa, Even if they give you 6 months at the point of entry, 6 months cannot keep you until fiscal year 2026. So at the end of the day, you are going to be out of status. And being out of status is not allowed when it comes to employment-based visa category. So that is one challenge. Second challenge, if you decide to change to student visa, yes, that is possible. But again, it is not easy because number one, you come in with a B1, B2 visa. The maximum they will give you at the port of entry is 6 months. Now, if you come in and immediately you enter, you start looking for admission, you get I-20, and then you apply for F1, F1 status, it raises the question of your intent. Immigration can deny the application on the ground that you lied when you enter, especially if they ask you at the port of entry, why are you here? And you tell them you are here to visit. So they may see it as obtaining entrance, gaining entrance by misrepresentation. So it could be denied. Generally, for anyone who entered the US with a B1, B2 visa, if you are going to change to student visa, it is advisable that you stay for some time, maybe 2-3 months before you even start the process. Let me tell you something that a lot of people don't know about student visa. Every time you apply to any school in the US, a school that is authorized to issue I-20, as soon as you are clicking submit to your application, ICE is getting a copy of that application. So because you cannot get admission to any school in the United States by filling physical application, they will tell you go and do it online. When you do it online, they ask for your information, they ask for how you intend to provide financial support for yourself, they ask for all these things. Once you provide all the information and you click submit, as you are submitting it, ICE is getting a copy. ICE is Immigration and Customs Enforcement. Remember, it is ICE that issues a civic number, and the process of change of status to student requires you to obtain civics number. It also requires you to pay civics fees. So as you are doing all these things, ICE is already aware. So you are not dealing with only the school, although the school is the one you are communicating with, but you are indirectly also communicating with the United States Immigration and Customs Enforcement. So that is why you have to be careful. Yes, it is possible to change status from B1, B2 to student, and we do it for people all the time, but it is very technical. You have to be careful. There is even some very, very technical issues. There's a specific window of time that USCIS look into in determining whether to approve or deny your application. For example, if your request means that you are going to start your classes more than 30 days before the expiration, or is it the expiration or the commencement, that may be a ground for denial. So there are so many things that has to be considered, so many things that have to be taken into consideration. But is it possible? Yes, it is possible. The next question. I have lived in the UK. I had an H1B visa interview, my first H1B, but I was told the name of the employer in their system is different from the I-797 I have. I was refused with admins processing chances. Question mark. I'm trying to understand the question. Or is it a continuation? This question is from Adedayo Adesonya. I don't get the question. This is just an explanation.
I was told the name of the employment that is okay.
I was refused with administrative process
Oh, I
chances.
guess she wants to know if he has any chance of still coming on the H1B, maybe still under administrative processing.
I don't understand the question.
I'm thinking maybe they're trying to verify that it's the same person.
Yeah, then it means she has not been refused. If it says it was refused, if the visa is refused, it's refused.
Yeah.
Or maybe if the visa is still in administrative processing, that's different. If the visa is still in administrative processing, it means that they will find out if it is the a lot of employers, the name that usually show up on their pay slip or W-2 is usually different from their business name. I've seen that over and over and over, especially when it comes to W-2. You will see some names and you see the company name from Arizona. Meanwhile, you are working for one employer here in Dallas. So, and some of them, even Bank of America, you know that there is Bank of America Corporation, there's Bank of America NA, there is Bank of America, all kinds different companies, they have different entities, they have different names. So it depends on who. I mean, if that is the sole reason, they will find out. All the employer needs to do is to submit documentation to show that the employer and the name on the petition, they are the same person. That's not a big issue. It can be resolved if it is administrative processing. But if they have already denied, they will tell you why it is denied. And of course, H-1B is also a non-immigrant visa, so it has some element of discretion. The next question, do I need to be in status to file for EB1 from within? Oh yes, every single employment-based petition requires the applicant to be maintaining legal status. That is the gold standard. There is no exception. Well, except somebody who is eligible under 245I, which means you must have an immigrant petition filed on your behalf before April 30th, 2001, and then you can pay a $1,000 penalty for you being out of status. That's the only exception.
There's a second part.
Okay, part 2. If the petition is approved and the green card denied, what then can be done? This is a situation for someone in removal proceedings due to failed asylum petition. Unfortunately, there is nothing that can be done because if this person is already in removal proceedings, it's even more complicated because I was going to say that if the petition is approved, depending on how long the person has been out of status, because there is something called 3 and 10-year bar. If the person was out of status for a period more than 6 months but less than 1 year, that person is barred from re-entering the US for a period of 3 years. So what you could do, process the approval through the National Visa Center and go back home and stay there for 3 years and then apply. You come back in legally. However, for someone who has overstayed for a period of over 1 year, that person is subject to 10-year bar. So that one may be problematic. But in this case, the fact that this person is even in removal proceedings is another complication, because if you are already in removal proceedings, if you leave, that will be self-deportation. And if they order you removed, that will also subject you to 10 years before you can re-enter the US. So this is not a good situation at all. And I'm sure this is one of the disadvantages of applying for asylum. But you know what? This person, you see, this is one of the reasons why I'm always skeptical with questions that are not detailed. This person didn't tell us when the asylum was filed. What was his status at the time the asylum was filed? Because why that is important is that if this person was in legal status at the time the application for asylum was filed, I may still be able to help you without you leaving the US. You can still get your green card even in court without leaving the US. But again, these are assumptions because the questions are not very clear. If you are the one that sent this question and you are listening to me, please contact us after this podcast. We may be able to help you depending on the answer to the question. The main question I ask for you is, at the time that you filed the asylum application, were you still in legal status? If the answer is yes, I may be able to help you. But if the answer is no, unfortunately, I will not be able to help.
It also says that they're a medical doctor with over.
Is that the
10
next
years.
one?
No, it was. I didn't include that part. I didn't see that part until just now. They also said that they're a medical doctor with over 10 years experience in Nigeria. That's part of the EP1. I don't know.
Well, I believe I've answered the question. If the answer to the question is yes, let the person just contact us. But if the answer to the question is no, then there's no point because, like I said, employment-based visas require people to be maintaining legal status at all times. Now, the next question. Can I get a green card through marriage if my U.S. citizen spouse is disabled and getting benefit under SSI? Oh yes, disability is not an issue. Your spouse may not be able to have enough income to sponsor you. All you will need to do is to have a joint sponsor. Yes, you can get your green card. That's not disability is not a disqualification. The next question. I came to Miami, Florida in 2021. I was referred to court for asylum. My master calendar hearing is in 2025. Recently, I got married to US citizen. Is it continuation? Okay, continue. How long is it going to take for the I-130 form to get approved? What is the good faith marriage evidence that's required the most when the alien is in removal proceedings? I'm trying to read the question again. This person didn't say. You see, let me say this. Please, when you are sending questions, please provide valuable information that can guide us. This person just said I was married to a US citizen. He didn't tell us how he entered the US. Did this person enter legally or not? Because that is a deciding factor. That is a major decision impact. If you enter with a visa, yes, you can change your status if your petition is approved. You don't even need to get the petition approved before the removal proceedings is terminated. I mean, you can submit your I-130 petition, show the evidence of the pending I-130 to the immigration judge, attach evidence of your good faith marriage. The judge will consider the marriage. If the judge asks questions, they can decide to look into the I-130 and look at the possibility of it being approved, and then decide to grant continuance until I-130 is adjudicated, or even the government may move to terminate the proceedings to allow USCIS to process it. But again, whether you enter the US legally or not is a determining factor, and I don't have that information from this question. So I really don't know if this person can get green card through this marriage or not. But I need information to know, did you enter with a visa? Even if you didn't enter with a visa, were you paroled? Did you when you ask for asylum, were you paroled? If you are paroled, yes, you can still do it. But if you did not enter with a visa and you are not paroled, then you may need to go back home in order to get your green card. And being in removal proceedings may not help that, especially if you already apply for asylum, telling them that you are afraid of going back to your home country. That may be problematic. If you send clarification before the end of the program, I will still go back to it. But if you enter legally, yes, you can get your green card here without departing the United States. The next question. I'm a pilot in Nigeria. I just attended a meeting with an airline in the US. They are telling us to go ahead and file EB2 NIW so I can work for them, telling us to apply under the category of being an underserved area because currently there is a need for more pilots in the US. Is this true? Can I get a green card this way? You see, there are so many things that people say that are not true. Working in an underserved area is not a ground for EB2 NIW. And I can tell you that authoritatively, it is no. Authoritatively, you can quote me anywhere and I can defend it. It is no. That is exactly why labor certification was created. Labor certification was created to address labor shortages. So areas that have low employment or area that are underserved, those are the areas where you can apply for labor certification and get it approved easily. So I don't know about pilots, but if pilots are in high demand in the US, if pilots are underserved in the US, go back to this employer, tell them to sponsor your labor certification application on the basis of underserved area. They will get it approved as quickly as possible. But it is not a requirement for NIW, EB2 NIW. You cannot get it approved. I can assure you of that. You cannot get it approved. But if the employer, if they really know that pilot is an underserved area, all they need to do is to apply for labor certification on your behalf, place advert in the newspaper, comply with all the labor certification process. Of course, if there are no pilots, nobody will apply, and then the labor certification application will be approved. And with that approval, the employer will go ahead and submit immigrant visa application on your behalf, I-140. That is not something you can do on your own. So if the employer is telling you to go and do it, they have no understanding. It is not, it doesn't work like that. It doesn't. NIW is the only employment base you can do on your own. And of course, on being in an underserved area is not it's not a requirement for NIW. In fact, you'll be denied, because to address labor shortages, that is exactly the purpose of labor certification. So to go back to the last question, can I get green card this way? Yes, you can get green card, but it has to be through your employer. It is the employer that will sponsor you. It cannot be self-petition. So the employer can apply for labor certification on your behalf. And if it is approved, they file immigrant visa on your behalf. And if it is approved, that is when you now process green card application. Yes, you can get it, but the employer has to be the one doing it for you. You cannot do it for yourself. The next question. Am I 245 grandfathered? I'm a beneficiary of my dad's petition filed in 1991, and I have an F4 petition pending, which is not approved yet. Can I still do adjustment of status or wait for 14 to get it current? Or wait for F4 to get it current? I'm trying to get this again. 245 grandfather and beneficiary of my dad petition. So are you saying that, is this person saying that the 1991 petition is not current yet? I'm trying to understand what the...
No, I think oh, okay, I'm not sure about.
The beneficiary of his dad's petition.
Yeah, a petition of 1991, it will have been. I don't think there's any country that is that backward. I don't think that there's any country that is that backlog, even though this person didn't say which country he or she is from, but I don't think that any country is that backlog. So if you are a beneficiary of a 1991 petition, that petition should have been current. So, and again, I don't understand the question. So is this person trying to see if we can adjust status on what basis here? Because if you are talking of F4, that is sibling. So you cannot use the priority date of the grandfathered petition for that purpose. That's not the purpose of 245I. The purpose of 245I is to waive unlawful entry. That is the purpose, not to change visa priority date. No, that's not the purpose. The next question. Okay, I think this person sent a follow-up. Sorry for my question error. I meant, what are my chances after H-1B refusal based on administrative processing? I was earlier given a pink paper with PIMS written on it. Well, if there are still administrative processing, what I'm going to advise you is contact the employer, the one that sponsored the H-1B. Contact them. Let them contact the embassy. Let them contact the embassy directly, so they may be able to clarify whatever issues the embassy have regarding their name. So, and even if the embassy believe that the visa is not approvable, let them still contact the embassy. The embassy will provide a response to them. So, but if it is administrative processing, that is not a denial. That means they need to clarify a few more things before they grant you a decision. So that's not a denial. The next question is already past one, but I will still answer. Do we have any one more that is coming? Any more questions that are coming? Because I think I have the last one now that I'm about to.
Yeah,
We're gonna have to wait until the next session.
yeah.
Oh, we still have so many?
Mhm.
And then maybe we are going to do another series.
Yes.
Okay. Well, like I said, it's already past 1 o'clock today, but I'm still going to answer this last one that I have in front of me. What are the first comment? Thank you for doing a good job. You're welcome, sir. What are the things to do to change my status as a visitor in the US? Again, this is an open-ended question. I think the same person. Oh, it's a different person. Okay. Yeah, like I said, there are so many things that somebody can do to change status. If you came in with a B1, B2, you can change your status to student. You can change your status to other non-immigrant status, R1, H1B, L1, O1, P visa. There are a lot of things to do. You can also change your status. You can, if you are eligible. I mean, I don't know a lot about this person, so I don't know. If you are eligible, you may be able to apply for green card directly under EB1, EB2, EB3, or EB4, or even EB5. Again, I don't know how financially strong this person is. Remember, America is still a capitalist country. There are different rules for rich people in this nation, whether they admit it or not. That is the reality. So if you have money, if you have dough, you can get green card easily, stress-free. All you need to do is to invest $800,000. They will give you green card. They will give your family. If you are a man, they will give your wife. They will give your children, all your children under 21. There is no limit, even if you have 20 children. For as long as they are all under 21, all of you can get green card. It is stress-free. As you are bringing in your money, you can apply for green card immediately. So it is stress-free. So there are a lot of things that you can do. But for the purpose of this podcast, I'm going to advise you. We have been doing this podcast now for years, and we have covered lot of topics. Take your time, go over our podcast. I mean, we have dealt with how to get green card through EB1. We have podcast on how to get green card through EB2. We have other one on how to get green card through EB3, how to get green card as a self-petitioner. We have a podcast on how to get green card as a F4, religious employment. We have a podcast on how to get green card as an investor. I mean, we have all these podcasts. So take your time, go over it, and then you can narrow it down. If you have seen the one that you think you are eligible for, then you can ask more questions. And I've been told that we are going to continue this this series next week. We are going to allow open questions next week. That will be the third week that we are going into open question. But before I go, I think I still have one last question before I go. This question says, I came to the US on an F1 visa for a PhD program, but I couldn't continue the program because I couldn't find a suitable research advisor. What should I do to remain legally in the US? Well, if you say you, so I believe that for F1, I think your grace period is probably 60 days. How many?
Well, if they want to apply for reinstatement, it has to be within 5 months.
Yeah, but to even get out of status is what I'm saying. For if the only reason is because you are not, because that is similar to somebody who is giving EAD on a student status who is not able to get an employment. They have a 60-day grace period. So if your reason is because you are not able to find an advisor, I believe that you have a 60-day grace period. But after that, you may not be, you may be out of status. But eventually, if you are able to find one, just apply for reinstatement and provide an affidavit explaining why you are out of status. But you have to make sure that you didn't work illegally, because that will be a factor if you apply for reinstatement. But unfortunately, if you are on student status, you have to be maintaining legal status. So except you apply for family-based petition, those are the ones that they waive they waive it for people who are out of status. But for employment based and non-immigrants, they have to maintain legal status. So I believe it's already past our time, and because we have so many more questions coming in, we are going to continue with this series next week. Uh, Ordinarily, we had planned a particular topic for next week, but because we have this open series, we have more questions. We are going to continue next week by God's grace. So join us again next week, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. That is currently 1 p.m. Eastern time. That is 10 a.m. Pacific. And I believe that should be like 6 p.m. Nigerian time. Is that what you confirmed the last time? Currently 6 p.m. Nigerian time. So we hope you join us next week. Remember to invite your family, friends, colleagues at work. You know we are providing a lot of information, and the only way to continue encouraging us is to let others benefit from it. We are doing this because we have seen the benefits and we have seen the disadvantages when people, those who know the right information and those who do not have the right information. For those who have right information, things go smoothly for them. We have seen clients who entered this country and within 2 years they became a US citizen. And we have seen people who have been here 20 years, 30 years, and they still don't have any legal status. The major difference is information, and that is why we are providing this free information. In this country, information is key. Right information in particular is very key. There are so many information online, half of which are misleading, half of which are not true. So getting right information is essential to maintaining legal status in this country, and that is why we are doing this. We hope to see you again next week, God willing. This is Dr. Olu Asekun. God bless you.